Thank you very much.
Bye-bye, thanks.
Bye.
Would you like to wait longer, or would you want to start, Colleen? What do you guys think?
I'm happy. Well, if you're ready to go, I'm happy to go.
Yeah.
Good. So I will start sharing screen, if that's all right.
Mm-hmm.
All right. So,
Fine.
by any chance, are you seeing?
Yeah.
Influence on the first women lawyers in America. Okay, let me start my clock. All right. So, hello, I'm Colleen Graff. I'm a law professor at Pepperdine University, Caruso School of Law, which is located in Malibu, California, but we also have a campus in London. And I'm actually an English barrister, despite my American accent. And so I thought it was interesting to take a look at the British influence on the first women lawyers in the United States. And I take us from Anglo-Saxon time 1410 up to 1920 in 15 minutes, so I will move swiftly. The first, here we go, is I took a look at Professor Cristiana, who wrote about women in the Anglo-Saxon period, that they were near equal companions to the males in their lives, such as husbands and brothers, more than any other era before modern time. In particular, she notes that they had control of their separate property, even in marriage, which gave them a lot of weight to their opinions, and they had the right to make testamentary dispositions of their own property. And so Professor Fell argues that the differences were more in class standing than between the genders. 1066 changed all that. The relatively equal status of men and women under the Anglo-Saxon period gave way after the Norman conquest, because they introduced a feudal military society in which women could not compete. And so it was viewed that the rough and ready partnership during Anglo-Saxon times gave way because of this emphasis on the military contribution that could only be made by men, thereby relegating women to a position that was honorable but basically unimportant. We come to the 1600s and Lord Coke, who said husband and wife are one before the law, and the husband is that one. So and rumor has it that Coke's writings were on the Mayflower coming over to the United States. And so at common law, coverture was the protection and control of women by her husband that gave way to various rights and obligations. So upon marriage, a husband and wife were said to have acquired a unity of person that resulted in men having various rights over the woman's property. The woman basically was deprived of her power to enter into contracts and to bring lawsuits as an independent person. So we have the femme couverte and the femme seule status, and that was you were covered as a married woman with no legal or civil rights. And you could not own property, make a will, sue, or be sued. And you could come to court only as a representative of your husband and with his permission. And the femme seule was the unmarried or the lucky widow, lucky because you could now own property, conduct business, speak for yourself in court. And so there didn't seem to be a lot of inspiration to be a married woman when all of these rights were taken away from you. Well, the colonists brought over from the feudal times and the English court the idea that it was indisputable that a woman could act as an attorney, was known as an attorney in fact, basically as an agent to her husband. So the colonists brought over these feudal laws and customs with them, but the pioneer conditions that were present at that time meant that the value of women increased. So women would appear in court, conveyed land, could recover debts, signed leases, received rents, defended their husband's good name. sued and were sued on their husbands' contracts. But one of the most famous was a British woman who came over to the colony of Maryland in 1638. And she was a master negotiator, accomplished litigator, politically very savvy. She immigrated to Maryland. Her cousin, she had the good fortune of having Lord Baltimore, who basically gave her the right to acquire land, and she became the attorney, in fact, for Lord Baltimore. Governor Calvert, who was the governor of Maryland, went to England in 1643. Civil War was breaking out, and he was forced into exile upon his return. And so Brent was able to help him retake control of his property, which gave her some extra privileges, including that he made her his executrix and the Lord Proprietor's attorney. She became absolutely prolific in the courts, over 124 court cases in 8 years, more lawsuits than anyone else in the colony during those years. And she believed that she had the right and the duty as an attorney for the governor to be able to have a vote and a voice in the Maryland Assembly, meaning that she basically would be able to have two votes, one as an independent landlord and the other as Lord Baltimore's attorney. And she was very unhappy that they disagreed with her. They said such privileges were only allowed for the Queen. And so could this have been the first woman in America to make a stand for rights of women? There were lesser known women at that time who were lawyers in colonial America. But again, this is more as an attorney, in fact, as an agent. So we had Elizabeth Volks, who was signing leases for land in Virginia. And again, it was an association with her husband. Sarah Bland was representing her husband, who was a very rich merchant in London. He sent her to America with the power of attorney to buy and sell land and receive debts that he was owed. An interesting defamation action taken by Anna Young in defense of her husband. He'd been accused of hiring Indians to kill Christians, and she was successful in that. And then a name that might be familiar, Hannah Penn, who was the wife of William Penn, the founder of Pennsylvania. And she acted as his legal duty. Many times the men were much older than the women, and they died before their wives, or they were incapacitated as William Penn. And so she had his power of, actually she didn't have his power of attorney, but such was the custom that she was able to trump the femme couverte and be able to act on his behalf. The competing influences from Britain were, of course, from the famous William Blackstone and his commentaries on the laws of England, who continued that theme from Lord Coke, which is that a husband and wife are one person in the law, and that is the very being or legal existence of the woman is suspended during marriage, or at least it's incorporated and consolidated into that of the husband, who is there as her protector, and she's under his wings as she performs everything. The other influence coming over from Britain was none other than Mary Wollstonecraft, who caused a sensation in her writing on a vindication of the rights of women in 1792. So she was arguing that the educational system of her time was deliberately trained to make women frivolous and incapable of doing anything. And so she said, women and men were human beings. They have inalienable rights to life, liberty, and the pursuit of happiness. And women should be allowed the same educational system as men. And then they would not only be exceptional wives and mothers, but they would be capable workers in other fields in the profession. And so she looked at, this is going to be an improvement for all of society when women are emancipated. So we then have the World Anti-Slavery Convention, and what's interesting is that the abolitionist movement was a really important factor in encouraging women to seek equal rights, because many of the first women who were interested in the profession of law were involved in the civil rights movement. And it was during this abolitionist movement that women first learned to organize. They got the idea of holding public meetings. They started to learn how to conduct petition campaigns. They won rights under the abolitionist movement to be able to speak in public for the first time. And it basically evolved their philosophy on what was their place in society and their basic rights. However, women who were going over to this famous anti-slavery convention in London in 1840 were dismayed to learn that women were excluded and banished from attending with everyone else. They had to sit behind a curtain in the visitors' gallery. The unintended consequences was that two Americans who had come over separately for this convention were corralled together and started a lifelong friendship that led to the beginning of the women's rights movement in the United States. And that was none other than Elizabeth Cady Stanton and Lucretia Mott, who were pulled together at this time. And they, 8 years later, start basically the Seneca Falls Convention and debated the Declaration of Sentiments. This was the blueprint for women's rights and suffragette movement in America. And so the abolitionist cause started this movement to bring middle-class women out of their homes and encourage them to speak out for their rights and seek new professions. The first female lawyer in the United States in 1869 was admitted to the Iowa bar, Belle Babb Mansfield. However, she did not end up practicing law. Iowa was one of the first states to allow women and minorities to the bar, but she focused on college teaching. Interesting that even though there was so much influence from Britain, the first woman to practice as a barrister in England wasn't until 1919. And actually it was, 1919 when they removed the Sex Disqualification Act. And Helen Normington had applied to be a student at Middle Temple, which is my in 1918, but she was forbidden from being admitted until after the Sex Disqualification Act. In fact, it was hours after that was passed, and she reapplied to Middle Temple. They accepted her, and she was called to the bar. She also became the first British woman, the first woman actually to say that she should keep her maiden name professionally, and was the first to have her maiden name on her passport. Then English precedent and the move to admit Belva Lockwood before the US Supreme Court. It was interesting that the bars, and we can talk about that in the Q&A, the bars to the practice of law were several, but the main thing was that it was uniform practice of the court that only men are admitted to practice, and this has been since time immemorial in England, and the court knows no English precedent for the admission of women to the bar, and therefore, because there's no precedent, we can't change that. And she was denied the ability to appear before the Supreme Court. But there's a terrific editorial by Myra Bradwell, who started the Chicago Legal Times, and she ridiculed the Supreme Court decision because she pointed out, well, if we're going to look at the precedent also says that men need to be wearing wigs and gowns when they're appearing before the Court of Westminster. And are the men in the Supreme Court in the United States wearing wigs and gowns? Well, obviously we're not adhering to all the precedents, so therefore this is ridiculous. And so counselors have never been allowed that, so therefore they shouldn't be either. Finally, after much persistence, the US Senate passes the Lockwood Bill in 1879, and Belva Lockwood is admitted as the first woman member of the US Supreme Court. She could now argue a case before the US Supreme Court, but ironically, she could not vote. So we then have the influence of the British suffragette movement and its influence on American women. And we had the early 1900s, Lucy Burns and Alice Stokes Paul came separately and for separate reasons to the UK, but they were both very much influenced by the suffragette movement in the United Kingdom. and they joined Common Cause, and they were basically, they learned all sorts of tactics from the suffragette movement in the UK. And so they went back to the United States. I like to see this as the before picture of these sweet, innocent Americans going abroad to the United Kingdom, and they learn all of these tactics, and they come back, and there they are. Lucy Burns is going to jail on behalf of her convictions. Alice Stokes is in front of the White House protesting. And so the final chapter, of course, is women are able to get the right to vote. And rather ironically, we actually had a woman who was elected to Congress who was not allowed to vote. And so the only woman who ever voted to give women the right to vote, Lincoln, speaks on, speaks on the balcony for the suffragette movement, and the 19th Amendment is adopted in the United States, giving women the right to vote.
Great. Thank you so much. Great timing. I've been putting in the chat the 2 minutes and 5 minutes. Hopefully that's helpful. I can also, I don't want to interrupt. I sort of have been saying, you know, with my hands, but I don't know that people.
Oh, I missed all that. So I just was watching my alarm.
So I think that was terrific. And I love how it fits into the larger themes of this conference, which is legal history. And you really do trace, you know, the confluence of British and the US over time. So I'm really excited to later ask you some questions, because I'm pretty obsessed with women lawyers and the first women lawyers as it is. So what we'll do is we'll let the next panelists go, and then and welcome Oren. I realize you joined late, as you said. So maybe Rossella and Cristiana, would you like to take it over the screen? Thank you.
I'm sorry. Okay, can you see my screen?
Yes, fine.
Thanks. Sorry. Okay. So, in Europe, I'm sorry. Okay, now I can start. Apologies. In Europe, in the past, only people professing the official religion was regarded as full members of the political community. Those who professed another religion were expelled, persecuted, discriminated, and in the best cases, tolerated. Tolerance is usually regarded as a virtue. However, the expression religious toleration has historically had a negative connotation. As Mirabeau said, the word toleration seems to me a sort of tyranny, because the authority which tolerates might also not tolerate. In fact, religious toleration was a concession, not a right. What is more, even when dissenters were tolerated, they were not recognized the same rights as those professing the majority religion. Dissenters had a limited legal capacity and were subject to a number of prohibitions and limitations. The conception of religious minorities as dissenting communities can be still traced in the oldest legal texts in Europe, like the Danish Constitution of 1849. Rules for religious bodies dissenting from the national church shall be laid down by statute. This provision is still in force, but the full protection of human rights is now offered by the European Convention of Human Rights, which was signed and ratified by Denmark in 1953. Religious toleration in Europe was relegated to the realm of history in the age of emancipation in the course of the 19th century, when European states started separating citizenship from religion, although in different degrees and forms according to the concerned country. This separation emancipated dissenters through the recognition of, first, the principle of equality of all citizens before the law, regardless of one's religion or belief, and second, the individual's right to freedom of religion or belief. These two principles are distinct but related to each other. For example, Italian racial laws limited the Jews' legal capacity. The Jews were no longer equal before the law. but Italian racial laws did not formally limit the Jews' right to religious freedom. However, the recognition of human dignity required the recognition of both principles. One cannot be there without the other one. In Europe, the legal process of emancipation started in August 1789, when the French Constituent Assembly proclaimed the Declaration of the Rights of Man and of the Citizen, which recognized in France and in Europe alike, for the first time, the right to freedom of religion or belief. Under Article 10, no one could be disturbed on account of his opinions, even religious ones. Article 11 defined the free communication of ideas and opinions as one of the most precious rights of man. These rights did not only cover religion, but also beliefs, including atheism and agnosticism. In revolutionary France, the recognition of the right to freedom of religion or belief was not accompanied immediately by the recognition of the principle of equality before the law. Political rights were recognized to Protestants only a few months after the proclamation of the Declaration in December 1789. To Portuguese, Spanish, and Avignonese Jews, that is, Sephardi Jews, in 1790, and to everybody, thus including also Ashkenazi Jews, in 1791. The Constitution of the same year enshrined the principle of all citizens' eligibility to public offices as a natural and civil right. Whereas France recognized first the right to religious freedom and then the principle of equality, in Italy the opposite happened. As Cristiana is going to explain later, the principle of equality was recognized in Italy in 1848. But only 1 century later, in 1948, was the right to religious freedom recognized in Italy. Quite a different process of emancipation has characterized Norway. The 1814 Constitution defined evangelical Lutheranism as the official religion of the state. The King of Norway, like other European monarchs, had to profess the official religion of the state and was entitled to the right duty to protect evangelical Lutheranism, which was the right duty to protect the unity of faith and to combat religious dissent. Only in 2012 was this clause repealed. The Evangelical Lutheran Church is now defined as Norway's national church, which means there is a link between the church and the people and not the state. Article 2 of the 1814 Constitution expressly excluded the Jesuits, monastic orders, and Jews from religious toleration. The clauses on Jews and monastic orders were abrogated respectively in 1851 and 1857. 1 century later, in 1952, when Norway ratified the European Convention of Human Rights, the Jesuit clause was still in force. Norway was the only member state of the Council of Europe to enter a reservation on Article 9. The Jesuit clause could not be regarded as an illegitimate limitation to freedom of thought, belief, and religion. Only in 1956 was this clause repealed and the reservation withdrawn. Finally, in 1964, freedom of religion was recognized by the Constitution, and in 2012, an inclusive recognition of the Christian and humanistic heritage was added. In 1814, only evangelical Lutherans could be employed in public offices. In 1845, people were allowed to leave the Evangelical Lutheran Church, however, under penalty of losing the right to hold public offices. Thus, the principle of equality had to be sacrificed in order to enjoy a limited religious freedom. From 1878, only evangelical Lutherans could be judges and members of the King's Council, later Council of State, consisting of the Prime Minister and other ministers. From 1892, judges no longer had to be evangelical Lutherans. From 1919, more than half of the Council of State had to profess evangelical Lutheranism, and only evangelical Lutheran members could take part in proceedings on matters concerning the Church of Norway. This clause was repealed in 2012, but only in 2014 did the Constitution formally recognize equality before the law. Cristiana, the floor is yours.
Thank you, Rossella. I will analyze other countries now, and I will take into consideration England and Wales, and then we will switch to Italy. As you know, England and Wales, we can say that they had a concept of qualified toleration. We can see why. Since the Anglican Reformation, Catholics were subject to a lot of restrictions in the fight to reintroduce Catholicism as a dominant religion in the reign. The Text Act 1673 was avoiding the risk of any popish sitting in Parliament or exercising public offices, de facto restricting civil and political rights of Catholics. Then the Act of Settlement is definitely the expulsion of the Catholics from public life. The situation of the other dissenters, apart from Catholics, like Jews and Quakers and non-Trinitarian Protestants, was far from being idyllic. But you can think to the Mayflower travel from Plymouth to the North America in 1620, carrying Quakers in the new supposed free world. But the Toleration Act, 1689, changes the life of Protestant dissenters, and if Rossella, you can change the slide, please. And in the 1753, the Lord Erdwick's Act granted to Jews and Quakers the possibility to marry with their own religious ceremony. Nothing changed instead for Catholics that must wait until 1829 to see their equality and non-discrimination rights established with the Roman Catholic Relief Act. And only afterwards, with the Marriage Act 1836, the civil marriage was introduced into countries to allow people who do not want to marry according to the Anglican rite, having a marriage that was not religiously connotated. When arrives the principle of equality in UK, I'm speaking of a formal equality stressed by the laws, but for sure the emancipation, the de facto emancipation of minorities in UK started a bit earlier, I can say. Even if in the common law and in the unwritten constitution, the principle of equality is slowly raised up during the social changes that UK faced since the Industrial Revolution, it's only in the 20th century that the law changed accordingly. The French Revolution does not seem to have been for UK a turning point in the treatment of religious minorities, as it was in other reigns in the continent, especially in the civil law area. For UK in modern times, we can stress some stages through the Race Relations Act 1975, in which ethnic, but in this case, ethnic religious minorities were granted some degree of exemption from general rules to positive value their belonging. Then we can pass through the abolition of the crime of blasphemy and blasphemous libel, yes, and the Human Rights Act in 1998, UK were the last country in Europe to formally sign and receive the European Convention of Human Rights. So it's possible to distinguish two categories of dissenters, religious minorities in UK, Catholics and others. Catholics suffer the worst treatment because of the quarrel between the monarch and the Pope around the new religion rose in the 16th century. In Italy, instead, the principle of non-discrimination is the corollary of the principle of. The point was that using a similar process in UK, based not on a political reason but exclusively on theological ostracism, in civil law, Catholic-based tradition, Jews are the target minority for discriminatory treatment. Even in the French society, where, as my colleague said before, were granted rights to all, the notion of all seems always to exclude Jews. In Italy, instead, it was the contrary. The Cineo's law notion of all was the result of the great effort proposed also by the Jewish intellectuals and people to the construction of Italy as a political and social unit, and the king valued this effort, granted formal equality to all. This concept of equality was corrupted by the fascist racial laws until the Republican Constitution reaffirmed now definitely the notion of the equality in 1948. That's fine.
All right, so my paper, there are thousands upon, as many of you know, so there are thousands upon thousands of articles on reverse transplants or legal transplants in the comparative law literature. But when authors talk about transplants, they make an unstated assumption that the traffic of laws moves from countries with greater economic power to countries with less such power. I hope to rectify this bias by focusing attention on reverse transplants, which I label the movement of institutions, laws, and procedures from countries with less economic development to countries with higher development. And now the question is, well, why am I in this panel? I think it's because I have a case study of certain laws that are that relate to gender equality potentially. So laws prohibiting women from terminating their pregnancies on the basis of sex, I say, migrated from India to the United States. And this study is, I think, I use comparative law methods to help us sort through whether these laws are appropriate to transplant. So quickly, I'm going to talk about what transplants are there any reverse transplants, and how do we evaluate transplants? So my goal here is, unlike many scholars who look at transplants after the fact, I'm looking at them before the fact, and I want to guide practitioners and policymakers in formulating appropriate approaches to them. Okay, so the first topic, as everyone knows, early transplants were the result of the work of colonial nations to govern the colonized. Today's transplants obviously don't occur in that context. A well-known wave occurred in the 50s of the law and development movement, where American scholars were transporting American laws in the hopes it would promote economic development. Also 1990s, 2000s, non-governmental organizations rewriting constitutions and laws. But as the literature review suggests in the next part, one thing in common with the modern transplants I want to point out, even though we're in a post-colonial world, is that it's still guided by the relative economic strength of countries, typically, which I call global north as a metaphor to global south. What I'm characterizing as transplants, many scholars talk about this, but don't really give a good sense of what they are. I focus only on institutions, laws, and legal procedures, hewing closely to the traditional definition and focusing on the migration between nation states rather than intra-nation. There are a host of actors involved in the exporting, importing, not just governments, NGOs, lawyers, people in the host country, as well as the country of origin, as well as the reception country. Transplants can have multiple origins. They can be from China, India, Italy can borrow from multiple countries' laws, and that they do transform when they move cross borders. So we don't expect the law to be exactly the same just because it originated in one country. And exporters and importers can have multiple motives and origins in this. So for example, people who are working here on rule of law projects might actually believe, and some may be right, that transporting American laws to developing countries will actually promote rule of law. Or, intergovernmental banks might, or governmental entities might try to force law reform packages that correlate with neoliberal models to open capital markets for goods. So there are multiple hidden motives. And there are several sources of evidence. So scholars will look at the text of legislation. They might look at the text, they might look at legislative history and other sources to determine that the law comes from a foreign borrowing. So the question that I wanted to ask is, well, are there reverse transplant? Maybe I'm wrong. Maybe the laws are migrating from the global south to the global north. So the one way to do this is to do a literature review. There isn't a database of transplants. So with an eye to this question, I pretty much did a search of JSTOR for the words legal transplants, came up with 600 articles in the last 40 years, and looked at what transplants authors are talking about. So using GDP per capita as a measure of economic strength, I define legal transplants as transplants moving from global north to south, horizontal from south-south, north-north, similar levels of economic growth, and reverse the opposite from south-north. Now, the limitations of doing this kind of a review and trying to make a conclusion about what happens in reality is that it excludes wealth of transplants in books. It also doesn't talk about, it also wouldn't capture transplants where authors don't use that term. But nonetheless, despite that issue, I still think the proportion of transplants we capture is probably relatively accurate. So here's the findings. Authors, when they talk about it, they're really talking about north-south movements, but they don't explicitly state that. They don't explicitly critique that, which I do in this paper. There's some relatively few reverse transplants, and that's because I defined horizontal very narrowly. These 4 is from Turkey borrowing laws from India, Swaziland from Uganda, and Japan from Germany, and South Africa from India. So arguably, potentially also fairly horizontal. So based on this argument that there's few reverse transplants, I wanted to bring a case study into the literature to identify one transplant. And I think the benefit of identifying this transplant is that it allows us to think about better ways to evaluate the migration of laws before they occur. So by way of background on this case study, so sex-selective abortion statutes are in place in these 9 states. They prohibit a woman from terminating their pregnancies because of the sex of the fetus. And nearly half of all state legislatures in the US have considered these bills. The US House of Representatives voted in favor of the ban. And last term, the US Supreme Court denied cert on a case from the 7th Circuit, but Justice Clarence Thomas issued a 20-page opinion explaining why he thinks these laws are constitutional. And with a new member joining the court, it's likely that this will have very consequential meaning in the future. So, okay, well, why are these reverse transplants? These seem just like, anti-abortion people in the US trying to restrict these rights. One, because laws here, I'm going to identify how they fit all the characteristics. Here, we're talking about a piece of legislation from one nation moving to another, namely India to the US. India has a GDP per capita of 2,000. US has a GDP per capita of 62,000. And third, as previously mentioned, modern legal transplants are the work of a wide range of actors and not limited to governments. Here, anti-abortion groups are involved in borrowing the laws. These laws can be traced to India and China, and I'll talk about later what my evidence is for that. These laws have transformed. So India, it's a prohibition on sex determination. And it came out of the feminist movement. So no woman in India can learn the predicted sex of her fetus because feminists said, well, we're seeing women targeting girls for abortions way too much. But here in the US, it's only a restriction on anti-abortion, not a restriction on pre-implantation like IVF or sperm sorting. And these actors have multiple motives. We know the conversation is very divisive here. And while they claim to be pro-women and pro-equality, they also are clearly wanting to chip away at reproductive rights. So here's just one piece of evidence for the origins of these laws in India. This is from a quote from the bill in the US House of Representatives, where they're making reference to India and China and the UK and saying those countries are doing way better at their laws, and UK is actually wrong, it doesn't ban it, and we need to provide more protection for girls and women. So I argue in the paper that one of the ways, many of the pro-choice activists and legislators in the US are actually voting and supporting these laws. And in part, they are looking at through the human rights lens, right? So they think the idea is, well, in India, this is a problem. Immigrants are coming to the US from India and China. And, therefore, if we believe in universality, then we must prohibit and ban this practice here. But I think that here we need to look at comparative law methods. They add a better framing and a better picture because they're agnostic about whether laws should move across borders or not. It gets us out of the intractable debate of cultural relativism versus universalism in international law. Comparative law scholars have spent significant time thinking about the global migration of laws, but they've largely critiqued it, as I mentioned, after the fact. So critics of the law and development movement in the 50s and 60s in the US that I talked about, they looked at the aftermath of the mass export of laws and saw how problematic it was. And their solution was, well, the activity should end. They didn't propose ways that acknowledges that there's global migration, but how can we do it in a way that's appropriate, realistic, sensible? More recent scholars like Pistor and Berkowitz have focused attention on what makes transplants successful. But for them, they define success narrowly. They define success as whether it takes hold in the reception country, right? Again, their assumptions, unstated assumptions are transplants are from global north to global south, and the laws that are moving are appropriate and adequate just because they're coming from countries with higher levels of development. But this gets a little bit confounded and narrow when we're talking about the reception country being the US. Well, there's no reason to believe that the laws in those state legislatures weren't properly enacted, aren't being implemented. Here, that's just not the relevant question. The relevant question, I argue, that we should focus on when practitioners are considering transplants is looking at the origin country. We should expand our gaze to look at the context of the origin country. Why did these laws get enacted in India? What are the practices? So if we're going to have a surface level discussion about India, I believe we need to have actually an in-depth discussion, looking at the scope and the consequences of the practice and appropriately distinguishing it from the US. So I do just that in the paper, looking at a comparative approach. If you focus on India, one sees that there are potentially 50 million women missing because of abortion. Why does this happen? There's a desire to have at least one son, and emerging studies show that the women's shortage in certain countries or the male surplus is correlating with sexual harassment, rape, and violence against women. And this sort of ties in a little bit to your paper, Colleen, with the idea of what happens when there's a shortage of men, right? Women become more, and I'm actually doing another paper on correlating child marriage to the shortage of men. The United States. So some empirical studies have shown that approximately 2,000, there might be 2,000 missing Asian American women, though we don't know it's because of sex selection abortion or whether it's IVF or prelim implantation means. Why are they doing it? Some immigrants might be sex selecting because of a cultural desire to have at least one son. My own empirical studies with sex ratios has shown that there's some family balancing involved. They want to have families with one boy and one girl. Of course, leaving aside whether that's appropriate or not, I'm just wanting to sort of set out the facts. And here we have no known societal consequences. All right, looking even further then on the causes in these two countries, India, dowry is illegal, but still exists, makes a girl, poor parents, expensive. Patrilocal system means that the girls go away. The sons are the ones that are relied on for support and economic opportunity in old age. In the US, these factors don't exist. Even in non-immigrants, we have no dowry. We don't have really a patrilocal system. Economic opportunities are greater, though not ideal, or nor do we have a better system of a welfare system. But again, not wanting to overemphasize that, but it is better than India. So what does this comparative approach show, right? So the question again that I'm asking is not whether the transplant will be successful or not, in the sense that whether it'll take hold or not, but it's whether the laws in the US will work for the same purposes they were enacted in India. In India, they were enacted and thought to promote gender equality, although even within India, there's a huge range of debate at this moment about the laws that were initially enacted in 1994. Clearly, the practice of sex-selective abortion is not carried out in a way that's problematic in the same way for women's equality in India as it is in the US. So some might argue, well, there aren't that many reverse legal transplants because global north countries don't have the same problems as global south countries. I argue that that's a false assumption. A country like India, for example, has encountered similar challenges as the US in terms of free speech, data privacy issues, affirmative action, regulation of corporations. And as you can see from this quote from Justice Ginsburg, she also agrees that it's valuable to look to global south countries. And in a way, it seems odd. I do hope that in 5 years, my paper is irrelevant. The people are in global north are looking at laws on the basis of whether relevant and not discounting global south laws just because they come from countries with less economic development. This puts too much emphasis on law as a form of engine for growth rather than law as a form of social justice, environmental protection. There are all these other hosts of things that we should be thinking about and looking about and have sort of a global migration of laws that's sensible and without regard to economic status of countries. So thank you. I will stop sharing my screen now so that Oren, you may take over.
Okay, let me see if I can share my screen. Can you see my screen? Everybody okay? Yeah, yep. Perfect. All right. So first of all, thank you. This has been really fascinating, and I've been taking copious notes as people were going along. And I start with an apology for joining in late. I did this small business of teaching, but I'm glad that I'm here. I'm also thankful for those who are in here because I know that there are quite a lot of other options in this annual meeting, and I'm sure that all of you, like me, wanted to be in all of them, but we can't. So everybody is here, great. The presentation that I have today is really part of a much larger project that I've been doing for the last several years. And I guess I need some explanation as to how it even got started. So November 9th and November 10th, 1938, the night of the 9th and the 10th, known as Kristallnacht, the night of the broken glass, or as it's now known in Germany, the Pogromnacht. Hundreds of synagogues throughout Germany, Austria, and the Sudetenland are destroyed, as are thousands of Jewish homes and businesses. Hundreds of Jews are murdered, and rough estimates put at about 30,000 Jews, 30,000 men that are sent to concentration camps such as Buchenwald, a concentration camp that is just outside the picturesque town of Weimar. 2 days later, 75 miles away from Weimar, Sol Lande receives his doctorate in law from the University of Leipzig, probably in absentia, because Sol Lande is Jewish. And by receiving his doctorate in law, he becomes the last Jew to be awarded a doctorate in law in Germany, but apparently in any academic discipline by a German university prior to World War II. Now, more than 7 decades later, back in Leipzig, there is a conference that goes on, Anwalt ohne Recht, Lawyers Without Rights. There's an exhibit there about Jewish lawyers throughout the, basically just coming up and then in the Third Reich. And Sol Lande is a major, or the life of Sol Lande is a major part of that exhibit. In the front row of that exhibit, or kind of that getting together, surrounded by German judges, German lawyers, and law professors, are Sol's 2 daughters, one of whom is a retired lawyer, married to Sol's son-in-law, a retired judge, as well as Saul's two grandsons, my brother and myself. And it was there, looking around and seeing the crowd, the judges, the lawyers, and the law professors sitting, that I decided that I'm going to write this paper, the specific paper, and do the research about the role of law professors in the time of the Third Reich. Now, why law professors? Well, the first answer is an obvious one. I'm a law professor. This is an interesting thing for me to see the role that law professors played, to think about the accountability of scholars in general. But it goes deeper than that. First is that scholarly treatment of the role of law professors during the Third Reich is still actually lacking. We have quite a lot of literature on the role played by judges, by lawyers, by philosophers, by medical doctors, but we hardly have anything about the role of law professors. And this is especially interesting because law professors in Germany then, as today, have a special elevated status, and they enjoy special elevated respect by the public as well as by other legal scholars, by judges and by lawyers. That gives them, or gave them, a unique opportunity to resist National Socialism, and yet not a single professor of constitutional law, of administrative law, of public law actually actively resisted. That elevated status of professors also gives them the opportunity to set out substantive guidelines to judges and lawyers. Unlike the common law system, the civil law systems are very much dependent on the writings of academic scholars, and judges and lawyers use those writings heavily. So, as other parts of my research show, there was in fact a lot of dependency on what the legal scholars said. In fact, law professors prepared the intellectual preconditions, if you will, for the Nazi seizure of power, as I'll demonstrate later. And finally, I'm going to talk about this myth of a few bad apples, that actually everybody was okay, and there were just a few bad apples that supported National Socialism, and debunk that. I will also mention that another part of that research goes to the famous Hart-Fuller debate and looks at that debate afresh, but I'll leave this aside. Maybe if we can get to that in Q&A, we can go there. So, a few words by way of background. Jews in the practice of law in Germany and Austria in general were represented far above their percentage in the population. Law was one of the unrestricted professions in terms of admissions and practice, and as a result, 60% of all attorneys in Berlin, 80% of all attorneys in Vienna were of Jewish ancestry. And when the Nazis come to power, they promulgate two laws, both on the same day, April 7, 1933. The first law is the law on the admission to the bar, that basically says that attorneys of non-Aryan descent could be excluded from the bar. All those attorneys, first and foremost obviously Jews, had to reapply for admission. There were two exceptions, and actually, interestingly enough, and we can talk about those if people are interested, those two exceptions made sure that two groups of lawyers will find it extremely difficult to reapply: young lawyers and women. And so the old Jewish lawyers could reapply, and of course many of them were still disbarred. By 5 years later, by September 1938, basically the legal profession became untutored, basically Jewish free. The second law is the one that I want to look at more closely, and that is the law for the restoration of the professional civil service. And when we talk here about the restoration of the civil service, right, it says that unreliable elements and non-Aryans will be dismissed from public service. And when we talk here about public service, we are talking about judges and law professors. And with one fell swoop, 1,700 faculty members across all disciplines were dismissed. 15%, those 1,700 were 15% of all faculty in Germany at the time. Of those 1,700, 80% were Jewish. In the law faculties, the situation was much worse. 1/3 of all law professors were removed overnight from their positions in law faculties in Germany. And those positions were rapidly filled in by young teachers of nationalistic orientation. By 1939, 6 years later, 60% of all law professors teaching in Germany were appointed in those 6 years between 1933 and 1939. The other 40% were there before, but 60% were appointed in those 6 years. Similar numbers also were in the student body. So not only the students, 90%, by 1938, 90% of all students in German universities were organized in the National Socialist Students Association. But in addition, training camps were put together to train budding attorneys. So here's an example of a training camp, and the Prussian Minister of Justice, Hans Kerl, visiting such a training camp in which, as you see, the law is being hanged. The guy to the right, who's happily hanging the law, is a senior public prosecutor who's also the head of the camp. Right? So we have those camps for budding lawyers. They have to go and be trained in those. Now, the law professors, right, in the German universities that are put into position after 1933, or even those that were there before, eagerly rush to publish new materials. There is an explosion of new articles and new books coming out after 1933, and basically all of them are trying to substantiate the authoritative basis of National Socialism, as well as justify and legitimate the actions of the regime. And they do so, among other things, by using value-based scholarship. So all of their scholarship is designed to address and to be interpreted and to be in accordance with the German spirit, in accordance with the people's community, with concepts such as honor or blood and soil that are becoming the guideposts for scholarship. And in that, not only law professors, but then also courts follow these norms in order to basically reinterpret, including laws that were put in place before 1933. So Rossella mentioned, for example, the legal capacity. German judges and German law professors get rid of Jews as being entitled to legal capacity by basically saying, well, legal capacity is only given to people who are alive, and then they're doing, by way of analogy, Jews are like dead people, therefore Jews don't have legal capacity. We don't need to change the law, we just reinterpret. Professors of law were astoundingly productive in creating and in establishing the National Socialist legal system, right? And they saw it as their task to bring about coordination and synchronization of the legal profession's thinking parallel to the coordination and synchronization that takes place in legal institutions that already took place actually by the law of 1933, right? This homogenization of the profession. And as I mentioned earlier, the vast majority of law professors not only do not voice any sort of apprehension, not only do not voice any sort of opposition to National Socialism, but rather they affirmatively support Nazism. Now, there can be many examples here, and I'm sure some of you are familiar with the writings of Carl Schmitt. I wrote quite a lot about Carl Schmitt and why, in a sense, he is an odious figure. Unfortunately, Carl Schmitt, who was the crown jurist of the Third Reich, has become, in recent years, the darling of American scholarship, both on the right and, unfortunately, also on the left. I think unjustifiably so, but we can go to that. But I also detail in my writings others less known than Carl Schmitt. And I want to actually just mention one of them that in Germany is known and in the United States basically nobody knows about. Theodore Mounts. Theodore Mounts, the reason I'm mentioning him is that Mounts became, after the war, the co-author of the most authoritative commentary on the West German Basic Law, the Constitution. He was in fact dubbed the crown jurist of the Basic Law. The leading treatise on the Basic Law is his. This is the first edition that was published in 1955. It is still in print. This is the 33rd edition of that book, published in 2018. It is still the leading commentary on the Basic Law, the German Basic Law. Between 1932 and 1952, Mounts taught in Freiburg and then in Munich. And upon his death, his obituary described him, and I quote, as a kind and reclusive man. Now, this kind and reclusive man was also an ardent supporter of National Socialism. This kind of reclusive man talked about the will of the Führer as the central legal structure. The will of the Führer is the source of all legality, which means also that all other legal institutions have to follow, which means that the administration of justice can never hinder the political decisions by the Führer. And as a result, for example, Mounts argued that all arrests, all detention made by the Gestapo were not reviewable by German courts because they were sovereign acts that were basically the highest form of administrative law, and as such could not have been reviewed. Mounts, this kind of reclusive person, rejected liberalism. He saw this as degenerative because of its call for individualism, of its call for rights, of its call for separation of powers, and talked about the, and I quote, the fatal predilection of Jewish theorists of administrative law for the liberal doctrine of the Rechtsstaat. German law professors, all right, paved the intellectual road, as I said, for National Socialism by their incessant attacks on Weimar Republic and the Weimar Constitution. Let me just give quickly and try and kind of wrap up real quickly some of the ways by which they did this. They juxtaposed the predilection of Weimar, of parliamentary Weimar, for discussion, and they replaced it with their penchant for the capacity to decide. Against Weimar, again, I'm going back to the previous papers, against Weimar's effeminate passivity, they posited the masculine cult of action and will. Against Weimar's focus on what judges and what legislatures do, they said the important thing is the sovereign dictator, he who makes the rules, he who decides. Against Weimar's liberal insistence on such things as individualism and individual rights, they put together the national, racially homogeneous and coordinated community. Against Weimar's tolerance, or what Schmidt kind of called with disdain cosmic tolerance towards everybody, they suggested the dichotomy between the friend and the foe that led to the inescapable necessity for the physical killing and the existential negation of the foe. And against liberalism, misguided attachment to general norms that apply to at all times to everybody, they presented the notion of the exception or of the emergency. Now let me ask you here, because I have one more slide. Can I actually go, or if not, I'm happy to stop?
I think it's fine. We have until 5 to discuss. So if you want to, if you have,
I hate doing the time hugging thing, but okay. So stop me whenever, and I will stop on cue. So let me just kind of quickly explore what might have led German law professors into this abyss of moral decline, and I hope that at least our Italian colleagues recognize the 9 Circles of Hell by Botticelli on the right-hand side. So I think we can highlight several things. The first thing is the social elitism and conservatism of German law professors. Basically, almost all of them came from the middle and upper classes. They were conservative nationalists, anti-republicans, long before 1933. And if there was one thing that they loathed, was the fact that Weimar had this leveling consequence of democratization. They could not forgive Weimar for democratizing, for opening up things to everybody. Against Weimar's kind of discussion, parliamentarism, maybe even instability, they all pined to the return of the man of action, right? They all thought about Bismarck and Germany's grandeur. If only we could go back, right, to those times, that will be so much better. And we are talking here especially about a younger generation of law professors that were shaped by World War I and by its national humiliation. So against Weimar's instability, and they actually emphasized not only personal insecurity and not only party politics, they even talked, and again kind of ties to some of the papers we heard about before, sexual degeneracy. Right? That was one highlight of Weimar and why Weimar should be gotten rid of, and we should all go back to German romantic ideas. Right? But another element was the Constitution of Weimar. And the Constitution of Weimar included this infamous Article 48. And Article 48 said that when faced with threats endangering the public safety and order, the president could take dictatorial powers to deal with those type of emergencies. Between 1919 and 1932, Article 48 basically turned into the exclusive source of governmental power. The German government, the Weimar government, the democratically elected government, basically ruled the country through executive decrees. And law professors and then judges basically interpreted Article 48 extremely broadly in order to give the government the powers to deal, obviously, with economic disturbances, but with growing aspects of things that were not really seen as traditional emergencies. And then, of course, when Hitler comes to power...
I think, Gordon, maybe if you could just wrap up in a minute.
Yes, a minute is all I need. When Hitler comes to power, as Justice Jackson says, right, Article 48 was ready to be used by the Nazis in order to finish off the Republic. Two additional things within the minute. One is personal opportunism, with the kicking out of the Jews from the ranks of academia. You basically, overnight, you were promoted, and obviously your further promotion was dependent on your support for National Socialism. And finally, and we cannot ignore that, rank and raw anti-Semitism. Let me stop there, and thank you for giving me the time.
Thank you. So I'm happy to entertain questions from panelists to each other, from our audience as well. Someone like to start? Yes, go ahead, Colleen.
So I was going to ask Cristiana and Rossella, from intolerance to toleration, is there any kind of broad thing where you can say, this is why communities sought to change their laws to become more tolerant? So I'm thinking for Sital and my presentation, I look at the Black Plague and the Civil War, which meant that a lot of men were out of commission. They needed, sort of universities needed to, they needed enrollment, so they allowed women to come into law school reluctantly in the United States. So I'm just wondering if there was any kind of thing that was pushing the change in laws.
Okay, can I go first, Cristiana, and maybe then, okay. If we talk about the passage from intolerance to toleration, the leading motive is political opportunism, because at that time, especially in the 16th century, after the religious wars, Catholic countries did not tolerate Protestants. Protestant countries did not tolerate Catholics. But luckily, there were Jewish communities. Jewish communities could not be assimilated to Protestants or Catholics. and the Jewish communities provided very important services. So a number of states, with the passing of time, competed also to attract Jewish communities, and that broke the ideal of political religious unity. Just one example, the Medici family in Florence had a harbor in Livorno, so they wanted some Jews to develop the harbor, and as a reply, the Pope in Rome, who also had a harbor in Ancona, he also wanted Jews because otherwise Ancona harbor would not have been able to compete with Livorno. So at the beginning, it was political opportunities. And I would say, thanks to the Jewish communities, which could not be assimilated, little by little, the idea developed that this tolerance should be extended also to other religious minorities. And then, of course, we had political philosophers who talked about human dignity. But at the very beginning, I would say political opportunism.
Yes, of course, and also the social changing in the sensibility of common people, because after for example, the war of the 30 years in Europe, what changed was firstly the political approach to the centers in order to govern a sociological situation that was going to increase, in which diversity was an increases phenomenon that could not be no more governed through the ancient situation of segregation. So this political changing approach transferred to common people that started to live together, maybe even better. It was a biunivocal relation between politics and the social changing, because people mainly, very often, were inclined to tolerate the other one if they were not economically perceived as a danger. This is why, for example, as Rossella was saying, the example of the Jews, they were practicing very, very often specific jobs that other ones could not provide to European society. It is probably in this mutual exchange between politics and social behavior could provide this notion of, firstly, of toleration, and then afterwards, with the tragedy of the Second World War, was definitely changing to the conceptualization of human dignity as equality, as we now face. I want to say one thing to Oren. We have an example like the months that you said before. We had a jurist called Gaetano Azzariti that was the president of the race tribunal during the fascist period. Then after the war, the war became the first president of our constitutional court. So this idea of recycling people that were feeding the dictators and the Nazi period in Germany and Italy is quite common also.
Thank you. I will look it up. I mean, it's obviously fascinating and it's highly troubling. I mean, in Germany, obviously, I mean, the Allies try to do denazification, and the story that we normally hear is that how successful denazification was. It was not in the least, and it was the interest of both the Germans and the Allies to kind of let it go, because obviously the Allies needed West Germany against the communists, so that was the big deal. And so, for example, in at least one land in Germany, in Bavaria, 94% of all judges after the war were previous Nazi members of the Nazi Party. And that's not a unique thing.
No, not at all, yes. Italy is quite the same.
Yeah, thank you.
Colleen, you have a hand up. I just wanted to ask you a question and then maybe turn it over to you on your paper. So I've read a lot about Myra Bradwell, and I'm interested to know how you kind of spoke about her as commenting on another Supreme Court decision, but she herself was the subject, right, of a U.S. Supreme Court decision where the U.S. Supreme Court denied this woman the right to practice law because they said, she's inseparable from her husband, and because this is the rightful place of a woman is not in the profession. So I don't know if you have any thoughts on that and any more background on how she fits into the picture of your story, and the story being also, how it seems like you're saying women's right to be lawyers was part and parcel of the story of voting being legalized in the U.S., which I think is fascinating, and I'd love to hear more about as well.
Yes, I thought Myra Bradwell was an amazing woman, and as you say, one of her misfortunes was that she was married, so she couldn't sort of hold out for all those reasons why women who could act on their own. But she was very clever in that she realized that the power was in the press, and so when she started this Chicago Legal News, she started publishing hot off the press the statutes and the judicial decisions, and she was very careful not to be too political, but she became the must read newspaper at the time. And then she slowly began to wield her influence. So, for example, she met Belva Lockwood because she invited her to come to speak in Chicago, and she was so impressed with her that they kind of joined forces, which is why we had Myra Bradwell weighing in with that editorial as she became more political in the Chicago Legal News, rather. And so a very influential woman, but she was strategic rather than trying to push things too much. And in fact, an interesting side was that the women who were fighting for the entry into the legal profession strategically decided not to push at the same time for the right to vote, which I think is what you were alluding to in her Supreme Court attempt. Part of their discussions were whether to tie that together. And in fact, her attorney said just the opposite, is, we're not calling for women's suffragette, no, that's not what we're saying. That's a step too far. And Susan B. Anthony was furious because they were sort of disavowing rights for women to vote in order to get through their entry into the legal profession. So I thought that was very interesting. Thank you. So my question was to Oren. I'm shocked. I'm really, really shocked. But as you lay it out, it makes sense, that these were the elites and that they're hearkening back to another area. But was there no Bonhoeffer type character who was just the sole, not one single person?
Not a single one. The best case scenario that one could say is that some professors went to that, what they call the internal exile, right? So they kind of closed in. But the problem was even those were the minority. If you just look at publications, if you look at pronouncements and statements, and again, especially, but not uniquely, but especially from the public law professors, not a single one. Not one.
Really very interesting and very shocking and disappointing.
Rossella, you have a question?
Yes. There were many fascinating things, but you talked about the difference in the legal status of femme seule and femme couverte. And I find it really strange, because usually in patriarchal societies, not married women are still subject to a male authority, like the father or the brother. But I understand that was not the case. Is that correct?
Yeah, that is correct. You had a lot of advantages on being femme sole, and that's what allowed Margaret Brent in those early days to be able to do what she did. And so but on the other hand, a lot of women who were married, they could fall under exceptions to the femme couverte rule. So if they had a business and they were seen to be independent businesswomen, then they would sort of have a femme sole type of abilities.
Thanks. That's very
But
interesting.
yes, you're right. It is odd. You would think that they would fall under husband, brother, someone, but no. And in fact, it was one of the things that changed the laws in California, where I am now, despite my virtual background, which was that a lot of women had huge property and they had no incentive to get married if it meant their husband would be able to have control over it. One of the reasons why this changed the laws in California is all these men had moved out west, wanted to get married, and the women had no incentive of getting married and losing their huge acreage and cattle and so on. So that was an economic incentive.
Thank you.
So does anyone have any other questions? I just have a quick one for Oren. What, to me, again, it was really fascinating to see it, and I loved your PowerPoint as well. Where did we, this is sort of really a story of, a regime where you can't raise your voice, right? Where you're persecuted, possibly, and where lawyers, like others, right, actors, were silenced who may want to espouse an opposite opinion. I'm wondering what other places, either historically or currently, that we might see this. Lawyers are always thought of as you're like the Atticus Finch kind of guy, lawyer, whatever his name is, right? We're protesting, we're at the forefront of everything. But again, these are regimes where courts might matter, where democracy might matter.
Sure.
So yeah, just other parallels that you've seen.
So I think it's a great point, and actually, I won't say dispute the premise, but kind of challenge the premise, because as Colleen also mentioned, in other areas, there were voices and people who spoke up. And some of them risked their lives, and some of them actually lived to tell the tale after the fact. It was not clear that if you speak up, you're necessarily going to be dead. But even if that were the case, again, we would think that there's a certain moral imperative at some points, right, to speak up. But again, as I said, not the lawyers. It's a really, really sad story about our profession. Now, the second question the second part is troubling in the following sense, because there is an obvious desire, let me put it this way, to bring that historical example to today's world, and to talk about things that we see around us today in the United States, around us today in Italy, for that matter, right? And the rise of extreme right and what appears to be somewhat of silencing of the legal profession. And I want to be cautious. I think there are a lot of lessons that we can draw from that. But I, for one, have always been cautious about drawing too facile and too easy analogies from World War II and from the Holocaust to scenarios that we see around us today, because my big fear is that to some extent trivializes the experience of those days. Now, that doesn't mean that there is not a lot that we can learn. And if there is one cautionary tale, is speak up. Speak up, because you have the tools. We give our students the tools to speak about justice, to speak truth to power. And we are in the most privileged, if you will, of professions, right? Especially once we get to tenure. I mean, we are untouchable. Fantastic, right? As I keep on telling my students, tenure means never having to say you're sorry. So, use that. You have that power. You've got to do it. You've got to use it. You cannot just sit in your cocoon and write, without having any sense of accountability. Words matter, and the words that we use matter. So, yes, we can go to other analogies, and thank you for raising this. I mean, we can you mentioned India. I talked a lot about, emergency powers in other communities, and emergency powers, for example, under Indira Gandhi, and what happened to the legal profession at that time is another fascinating example of, do you speak up? Do you not speak up? So, thank you for that opportunity to actually kind of talk about this.
Thank you. I think that was a terrific response. I really appreciate it. Really enjoyed all of the papers here. So if I know it's late in Italy, if there's no other questions or comments, I would close the panel then.
So Sital, I feel bad. I don't think we've asked you a question, and so I was gonna say was very interesting as far as what I'm looking at. Would you apply some of the reverse legal transplants between the laws in the United States and the UK, going back and forth with all of the legal profession and suffragette movement and so on?
Yeah, so that's interesting to think about. So the way I'm looking at it is sort of in the modern world, right? Yes, in the colonial context, all the British laws were transplanted to their colonies, right, as a way to govern and control, and that's where the common law obviously evolves from. Once you're in this sort of post-colonial world, the world economic order is sort of more marked differently. It's marked by disparity, it's marked by inequality, and I think at the point of your talking about the transplant, it would seem to me that the countries are maybe more parallel. But I would say we need to go back to that at that moment in history, was it reversed or not? We have to look at whether it was they were more parallel, they were more similarly situated at that point, economic powers, and maybe it's a more horizontal transplant than a reverse at that time.
Yep. And Oren, very important. How did you get your PowerPoint to open up on that first slide? Very impressive.
The tricks of the trade.
Oh, come on. All right, we'll get it out of.
For those who are interested, I'm actually not using PowerPoint. I'm using Keynote on Apple.
Oh.
I find that it gives you a bit more. If you think this is impressive, I mean, I can send you some of my others when I teach students. I can do flame throwing and things move between. It's we can do a whole new panel just on that.
That is, thank you very much, because I'm sort of stuck to PowerPoint because I've been too afraid to go to Keynote. So you've inspired me. Thank you.
Oh, well, perfect.
Great. Thank you, Sital. Thank you, everyone.
Thank you all. That was fantastic.
Thank you very much. It's been a pleasure.
This session.